Hi, I'm Lindsay with High Sierra Legal, and today we're going to talk about the dreaded probate. Probate, let's not do it. So, what is probate? So probate is the legal process of distributing dead people's things. That's it in a nutshell. What it really is that when people pass away, society wants to protect dead people's things. So society will lock down dead people's items, assets, what have you, to make sure that somebody just off the street doesn't come in and know that John Doe has passed away and I'm going to walk into the bank and say, hey, I'm John Doe's daughter. I should get that $100,000 bank account like we talked about. With that, there is a process to prove that I particularly might be John Doe's daughter and I am entitled to that bank account, and that is the probate process. With a will, you still have to go through probate. So I know a lot of people think, oh, I don't have to go through that. My heirs won't have to go through that because I have a will. Wrong again. All a will does is tell the court what you want to have done with your stuff. It is the roadmap through probate. And it's in fact called we prove the will through the probate process to make sure that it's accurate. Everything is what it's supposed to be and it was done correctly. And we discussed that in another video and also through my blog. So you guys can read a little bit more about wills and will formation and what should be included in a will as well then. So let's talk about probate and what the probate process is. So again, it's the court process to make sure that people are who they say they are, that they had the items that they said they did, and that those items or assets should go to their heirs or to whoever they have delineated or discussed on their estate plan through their will. What happens with a probate is it is a quite lengthy process because it goes through the courts, and the courts it's a process, unfortunately. A lot of times these timeframes are statutorily set and there's no way going around it to make it any faster. The first thing that you do is when someone passes away is you would get their death certificate. Double check to see if they have a will. If they have a will, then you're going to go ahead and file a petition with the court. First off, you're typically going to lodge that will if there is a will. That's filing it with the court. So the court has the actual physical original copy safe in their keeping, so nobody can now mess with it, change it, do what they need to do with it. The court is going to be the keeper or the custodian of that will. From then, the executor, if you do have a will go ahead and file a petition. And those petitions are typically dependent upon the value of the estate, and what level of probate you're going to file is dependent upon the value of the estate. So typically, nowadays, you're going to do a full probate just because if you own property, the property values are so high, it's going to kick it into that higher tier of probate. There are other lesser levels of probate. The first one is in Nevada, anything under $25,000 is a small estates affidavit, and that is for not real property, so no property or homes, but items such as a bank account that got left out, or that all they had was a bank account or a vehicle or something of lesser value that just needs to be transferred to usually one or two people, usually a spouse or a child. That needs to be transferred easily without kind of court intervention. It's a affidavit stating that there are no debts, that this person has passed away, there's been a time frame of usually 30 to 45 days, and that there's just this one asset that inadvertently got left out of an estate plan or was all they had, and they didn't list a direct beneficiary on it. So that's the first kind of tier. The second tier is called the set aside, and that's typically for assets under $100,000. It's a more truncated type of probate. It's usually for smaller items, maybe a mobile home, something, a couple vehicles, a bank account, something, again, that wasn't having a beneficiary on it that is needing to now be transferred to an heir that is over $25,000 but less than $100,000. After that, we have a summary administration, which is anything over that $100,000 but less than $300,000. And all that really does, it's the same as a full general probate. It just minuses one publication or notice requirement. So a summary and a general are going to be pretty much the same regardless. So anything over $300,000 in Nevada is going to be a general probate, and that is for assets totaling for the estate over $300,000. Again, most people are going to get kicked into that category just by the sheer property values these days. So from there, what happens? So person passes away, their executor is going to lodge that will, going to submit it to the court to be kept by the court for safekeeping, if you will. From there, that executor is going to file a petition depending on that level of assets and probate. From there, in that petition, they're going to put who they are as executor, if they had a will, did they die intestate, that means without a will, list all the heirs that they know of that are alive, and dead, honestly, we usually put it there, deceased or if they're alive, and that direct lineal succession. List their assets as well as they have their known and their approximate value. Any debts that they might have, we're going to list that too, and why that person feels that they should be appointed as the executor or administrator of this estate to go through probate to advocate for that dead person, if you will. So from there, you're going to file that petition, you're going to pay court fees, of course, and from there, then you set it for hearing. The court's going to then do their due diligence, make sure everything is done correctly, make sure you are who you say they are, that you're not, there for any fraudulent purposes, and also to give notice to the world that if a better person or a person with more authority or experience wants to challenge your request to become an executor, that they have the ability to do so. The court's going to double check everything, make sure everything is good, and then from there, they're going to go ahead and appoint that executor as the administrator or personal representative of that estate. So then they have the authority to go ahead and take care of things. Within that lag time of somebody passing away and the petition being filed before the hearing, again, society locks those things down. So bills still need to be paid. And I don't know about you, but I can't cover 2 mortgages. I hope you can. This is why estate planning is a very important process. So we're not having to go through this process and potentially have assets become, delinquent or go into foreclosure or, be repossessed. And somehow, even though they're going through the process, as we all know, creditors really just don't care. So during that time, those assets need to be taken care of, making sure that they are not going to waste, that they're being, upkept, if you will. If there's a property, keeping it, fiduciarily sound in that sense of that the mortgage is being paid, the expenses are being paid, the utilities, that it's not going to waste. From there, after you are appointed an executor, you're able to then access those assets because the court's giving you authority to, and those financial institutions are going to allow you now with that court's authority to handle these assets. They're going to talk to you now. You're able to find out what account balances are, what the property would be worth. If you wanted to sell it, you're able to do that. You're able to now marshal those assets. You'll open an estate account. You'll form an EIN with the IRS for that estate, open that estate account, and now start to funnel all those assets into one place. If the property needs to be sold, there's a process for that, and we can go through that in a different episode, which is a nightmare as well. This is why we like to avoid probate, because there's a lot of hoops that need to be jumped through that you would hope wouldn't have to happen, but unfortunately they do. You also have to let creditors know that this person has passed away, and so you do a notice of creditors. Every creditor that you know of that dead person, you're going to send them notification that that person has passed, that you have an estate open and probate, and if they want to make a claim, they are able to do so against the estate through filing a creditor's claim through that probate. So we file that, and we also publish that in the local newspaper, so they are able to make that claim and be known that they're able to make that claim so they can get their money. That's not also just for creditors, but also people who may have a claim against the estate for some reason. So there's that. Again, we talk about that sale of property. You're able to go ahead and get that done. You'll have to do court affirmation of that. There is a process for that. If there are heirs that are involved, you may have to do a waiver. You may have to get their acquiescence. There is a hearing that's held for that as well, to make sure that everything is being sold properly, that it's on the up and up, that you're not selling this property to Uncle Bob for $10 when this property is a $500,000 property. We want to make sure that it's at a fair market value because we want the estate to have this much money as possible. From there, you would do, after the creditor's time has run, usually it's either 60 or 90 days after that first publication. So again, another lag time with time on getting assets taken care of. We still have to wait now another 60 to 90 days after even appointment. So we're probably looking at 6 months into this probate at this point. You would do an inventory and appraisement. That's when you know all of the assets, what their values are, what they're worth, and where they are. Within that inventory and appraisement, you're saying, hey, we actually now have the actual values of these things, or things have been sold and put into the estate account. Say they had a car, you sold that for $10,000, that's going to go to the estate account, and we show that we sold the 1993 Corolla for $10,000, and here's how we can follow that transaction. Any other bank accounts, investments, 401ks that did not have beneficiaries, we're going to make sure that we know that those accounts values are there, and then the court's able to very transparently see what this estate is worth and where this money is coming from. From there, typically you'll pay, expenses, debts, what have you, if there are assets available to do so, because we want our estate to become a sum zero before any distribution happens, and that occurs as well with the estate planning if you have a trust. This also goes through the probate process as well. They're going to make sure that everything's taken care of, or to some zero, if you will, that all the accounts and creditors have come forward and those debts have been paid, and now we have X amount of money left over, and what happens to that. The court will then look at that, look at the will, and say, okay, well now the 4 children that were listed on there are now going to get an equal distribution. And from there, the court will say, everything looks good, everything has been paid, the executor has done their job. They have their ability to ask for fees and costs that they have incurred for this management aspect of the estate, in that sense, through the probate process, and they're able to get those funds reimbursed for them before any of those distribution happens. The court will then issue a final distribution order, and at that point, as an executor, you are able to go ahead and distribute those funds, if you will, or that lump sum or that pot of the estate to the respective heirs, whether through intestate succession, which would be lineal descent, or through the will and the wishes of the will. And that's pretty much probate in a nutshell. Very quick, dirty probate. Typically, again, it's going to be a very long process. 9 months to a year is a very fast probate. Usually they're over 12 to 18 months is a normal typical probate. So think about that time frame of what you're dealing with during that time. There are many different time triggers that happen through the filing of the probate. So there's, typically 3 sections. We have their initial first section of filings, then the second section after you've been appointed, then the third section to get everything kind of finalized. And within those sections, there are many filings that happen with the court to provide notice for the court. So the court is able to see, again, transparently what is going on with this person's estate. Disadvantage of a probate, again, is the length of it. It takes forever. Lack of privacy is another big one. People don't understand that through the probate process, those things are public record. That filing with the court is public notice. I typically, when I teach my estate planning class, we go online, we look at the court's website, and we scroll through people's lives. It is very transparent and able for anybody in the community to go through and look at somebody's life. I can see what they owned, what their estate value is worth, who their heirs are, did they owe money, where did they own property? Like, yikes, let's not do that. How do we avoid that again? We're going to do that through an estate plan or a revocable living trust. If you have property in another state, there's another issue there. So that's going to hold things up. So you're going to have to do an ancillary probate, which is a secondary probate for that outside property that needs to be managed in another state. That'll oftentimes lengthen the probate, again, keeping it in the courts for a lot longer time, because we're having to take care of property elsewhere as well before we can finish and wrap up the original probate in the state of which that person passed away. Typically, probate is filed in the state in which a person is a resident. That is where probate is filed, is where that person resided. Also, what happens to your children during this probate process? If you passed away and you had younger children and you didn't appoint a guardian, those children may not go to the people that you wanted them to. And that's a whole other filing that needs to happen, or court process, is getting guardianship of those children to the people that hopefully you wanted. Hopefully that's what you wanted them to go to, Uncle Bob and his wife, as opposed to Aunt Sally, who is not who you would want. But maybe Aunt Sally comes forward and is the one who advocates more, and the court gives the kids to Aunt Sally, and that's not what you wanted. This is why estate planning is very important, so you can provide those wishes so your kids just aren't up in the air. And your family kind of loses control of that estate. Like, they don't really have any kind of say. Again, it's all very much based upon statutes or laws or probate codes in that particular state of how these things go. It's very systematic, and it can be quite a traumatic experience, honestly, for families to go through. So I always tell the story of my one friend, her father passed away in his sleep. I mean, we can only be so lucky. He did not have estate planning in place. He did not have a will, and it took 4 years for that probate to get closed out. 4 years. Let that sink in. 4 years. Conversely, my other friend's father got unfortunately diagnosed with cancer. They called me and said, "Oh my God, what do we do?" I said, "Oh, we're going to put a trust. We're going to do a trust right now." They will still call me and thank me for doing that, because it made things so easy that they were able to get that entire estate wrapped up in 2 to 3 months total, including real property. So there are benefits to estate planning, but I just wanted to share what the process of probate is and kind of how it looks and why we want to avoid that and how we're going to avoid that. And that'll be in another video for you guys to watch, so you can look that up or check out my website. We're at highsierralegal.com, and follow me on Facebook and Instagram for more fun estate planning tips and how to avoid probate. Thanks.